Hello everyone, this is Priyanka from CS Priyanka's Profession Classes. So welcome to my class, and today uh, we are going to discuss on the topic Indian Contract Act 1872. So I have decided, though this chapter is very big, so I'm going to upload a small video on different types of topics under this chapter, that is Indian Contract Act. So today this video will be on the important definitions under Indian Contract Act which we need to read before going into depth. To understand the concept of contract, first we need to understand some definitions. So today we are going to discuss about those definitions. First, before starting the definition, let me tell you what do you mean by actually contract. Okay, what do you mean by this term contract? Contract means whenever any any businessman or any person wants to enter into any transaction with any other person, in that during that time we enter into an agreement or we enter into an contract. Got it? And when we entered into a contract, we have to prepare such contract as per this act, that is Indian Contract Act 1872. So basically Indian Contract Act 1872 is going to guide us how we are going to prepare the contract, what are the advantages or benefits of entering into contract. You can say this contract is a legal documents. That means, for example, like I want to buy a property from party B. Now, I have to enter into a contract with that party. Okay. If we don't enter with in any contract, without entering into contract, if we move on, for if we do any type of transaction, then we can say like this transaction is void. Why? In future, if any difference arise between us, that means the buyer is not paying the proper amount to seller on time, or any type of clash in future if arise, then both the parties is not going to get the legal benefits. Okay, if they go to the court against other, if one party is going to court against other, court will tell where is your legal documents. Okay, without legal documents, court is also not going to entertain you. That's why it is very important, like specifically when we are entering into any transaction with specifically with any stranger, then it is mandate for us to enter into a contract. And how you're going to prepare that contract, how we are going to implement or execute such contract, this act will tell you. So first slide is about, first definition we will read about proposal and offer. So proposal or offer is the same identical terms, means meaning is same. You can write proposal or offer, or the examiner can ask you any one of this. Now first of all, proposal and offer is defined in section 2A. Normally, you know, in a law there are million billion of sections are there, but 2 is allotted for the definitions. Now various term is coming under 2A, 2B, 2C. In this way it's happening, like all definitions are have explained under section 2. So proposal and offer is explained under section 2. We say subsection A of Indian Contract Act 1872. Now, as per this section, what do you mean by offer or proposal? So read the definition very carefully. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the asset of that other, to such act or abstinence, he is said to make a proposal. So when one person signifies to another his willingness to do or to abstain from doing anything, abstain, some new legal words will be introduced, like first of all, abstain, which means restriction. Okay, so now read, and one more, that is abstinence, which means hold back. Okay, you are restricting yourself to do something. Now this definition, read in three part. Okay, just do it, read in a three way. First of all, first part is when one person signifies to another his willingness to do, okay, or to abstain from doing anything. This is the first part. Second is with a view to obtaining the asset of other, to such act or abstinence, okay, to such act abstinence, he is said to make a proposal. So what do you mean by offer? For example, think A is a party, B is a party. Okay, now A wants to sell a property. Okay, so we can say like a property of A is on sale. Now A wants to sell his property. Now the question comes, A should declare this fact, okay, to everyone. Now A should inform others that I want to sell a property, or a property is there on sale, whether anyone is interested to buy my property or not. So if you want to do something and you are keeping the matter in you, then what will be the consequence? No one will come, and no one will come to know also you want to sell, and from where you are going to get the buyer, right? So you want to do, you first of all you should signify, you should tell your willingness, like what you willingness means, what you want to do, that first you have to express to others. So first of all is when one person is telling to another his willingness, that means what he wants to do, first he has to tell some, express to some other party, or to do, or to abstain from doing anything. So for example, think A wants to sell a property. First of all, either A should intimate or express the matter to B, or to many people, more than B, or more than one buyer, I can say, or else A will restrict himself from doing so. Either A will do this act, that means A will tell that I want to buy one property, or else A will restrict himself to tell that word, because A only till now A's thought is that A wants to sell his property. Got it? But till now he has not decided that actually he wants to sell or not. So there, this is this open definition. You can think of your own way. So for example, like if I wants to buy one property, either I will intimate about this matter, about this sell, that my property is on sale. Either I will declare or I will express this matter, or else if I don't want to sell it, I thought ki I want to sell my property, but currently I'm not prepared to sell it, then I will restrict myself to tell this matter to anyone. With a view to obtaining the asset of that other to such act or abstinence, he is said to make a proposal. Now, always one person will offer and other person will accept the offer. Now, if A is offering anything, then B, until and unless B accept, okay, they cannot move on into a contract. So this will be like, if A, B reject, then automatically this offer will go to C. If C reject, automatically it will go to D. So the thing is, until and unless any one party is accepting your offer, this offer is not valid. Okay, so this offer is open. So think A wants to sell this property and B wants to accept this property, but currently B's financial condition is not such that B will buy that property of A. In such cases, two option is there. B wants to take, okay, but though we don't have money currently, we cannot take. So maybe B should express that matter to A. Maybe A say, like, if A gives a opportunity to B that you can pay me on installment basis or any other thing. So what happened? To obtain the asset of A, either B will accept the offer, okay, or else B will restrict himself to accept this offer. Both the way I'm telling you in both the way. This definition is telling from the perspective of buyer and seller both. Got it? So this is actually proposal in the both the cases. So what I said, for example, you can take one example, A and B. A want to sell one property. So what happened? A will express his willingness to B. This is also, we called it offer. Okay. If B wants to accept, then if B accept, then it's okay. The offer is accepted, we can say. But B wants to accept, but B cannot accept due to some reason. And that reason, if B express before A that I want to take, but I can't take due to this reason. Okay, so this case also B is offering to A that this is my limitations, I cannot take currently, but I want to take. Okay, in that cases also we can say B is offering to A. So in contract act, buyer also sometimes offer to seller, or seller to obviously offer to buyer to sell his property. So now I think the definition is clear before you. This is one of the definition, first definition is coming, because first is offer. Okay, always seller will offer that this product is on sale or this property is on sale, whatever it is. Then we can call either I want to sell, I will tell that I will sell it, or else I want to sell, currently I don't want to sell it, I will restrict myself, okay, to sell it. Same case from the buyer's perspective also. Either buyer will accept it, buyer will buy it, or else currently buyer wants to buy it, but due to some reason buyer cannot buy it, means instant at this moment. So if buyer tells about his reason, about his problem, that will also be treated as a offer under the Indian Contract Act. So first definition we have read about proposal or offer. So under proposal and offer, I want to tell you some important point. First point is invitation is not an offer. Got it? Okay, I'm having a marriage ceremony, so I have invited you. You may come, you may not come. Okay, I have invited lot of people. So invitation is not an offer under Indian Contract Act. That is different. Next is whatever offer you want to do, okay, you should complete it. So you can say the second point, communication of an offer must be completed. You should not tell incomplete words. Okay, so you should say like, I want to sell it for this price, whether you are interested or not. So whatever your offer will be, the communication, what you will communicate to other person, should be completed. Now next is offer may be expressed or implied. Okay, so express means something you are offering in, you are writing something, or express means you are advertising in channel or newspaper, or you are just publishing the brochures and all. These are called express, whatever is expressed in the sheet of paper. And implied means it is a normal that you are going to sell it, or oral verbal communication, or it's the implied matter that expressed means like it is written in a written words, and implied means offer means, for example, implied offer means whatever is not written, means by your act or conduct it is clear that you wants to buy my property or product. Got it? For example, you just given me the booking amount and went off, so it's like by your act or conduct, by getting the advance from you, it is implied matter that you have accepted my offer. So offer can be expressed. Expressed means whatever is written, okay, in the paper or advertisement or brochure. And implied means what is not written, but by your act or conduct you are means it is clear that what you actually wants to do. Got it? And lastly, offer must be specific or general. Okay, specific means I want to sell one specific things. For example, I am having one specific bungalow and I want to sell it to my best friend. So see, all are specific. This is also specific. I am having a bungalow and that I want to sell to my best friend only. Got it? So this person is also a specific. But general means what? General means, for example, like I am having I used to sell, for example, I am having a shop and I used to sell the TV, computers and all gadgets and all. So these are general, anyone can come and anyone can select it. I will sell to anyone, no other specific people are allotted for me. So I can sell any proper TV to any party and I can take money. So these are all general offer. So this is the explanation of the first definition, that is proposal and offer. Next definition is promise. Promise is explained under section 2B of Indian Contract Act. First comes offer, proposal, next come promise. So what is actually promise? Let me read the definition first. When proposal is given by one person to other and if the other person accepted the same, then the proposal becomes promise. So always in a contract, minimum two party will be there, A and B. Now see, one party will be known as seller, one party will be known as buyer. So now think, if A is giving a proposal to B, or A is offering something to B and B is accepting the offer given by A, immediately it becomes promise because B accepted. So until and unless the offer got accepted by the other party, okay, so we cannot say this is a promise. Why? So when acceptance, in the sense, as per Indian Contract Act, it's said like that ki A is promising to B that he will give the property which is on sale to B, okay, and B is promising that as per Indian Contract Act, he is also going to follow the terms and condition and he will also pay for that property on time. So both A and B, both the parties are promising something to each other. Okay. So this definition is coming under section 2B. Next, section 2C. Section 2C explained promissor and promisee. What do you mean by promissor and promisee? We already knew, like one person will offer to other person. Okay. So the person who will offer, that person will known as promissor. And the person who will accept, that person known as promisee. So usually in everywhere, like in accounts or in law, if you observe the term very nicely, then you will come to know the giver we actually add OR and the taker or receiver always we add double E. Assigner, assignee, okay, payer, payee, Okay, maker, makee, promissor, promisee, consignor, consignee. Many terms are there. So usually you can remember in this way the person who is giving. That is OR we add. So here we are talking about promise. So promissor. And the person who is accepting is known as promisee. So see, as per section 2C of Indian Contract Act, the person making the proposal is known as promissor and the person accepting the proposal is known as promisee. Next come to section 2D, consideration. Consideration, we can say it's a legal term which means something in return. Okay, and that must be in value. Value means money. At first only I said this contract is made for two strangers. When one stranger is entering into a transaction or is doing some transaction to other stranger, that for that reason this contract concept came. Okay, we never enter into a contract with our father, mother. Means if he wants to give to our sister, we don't enter into a contract. There is a different thing like give deed and all, so we can gift it. But whenever the stranger is coming, there is a question of trust. We don't trust to stranger. That's why this contract came. They said both the parties should follow the terms and condition as per contract. Okay, so consideration means basically money. Okay, something in return. So if one person is transferring the property or product to other person, it is obvious that he is not going to give it at a free of cost. Got it? We were taking the example of between A and B. Think A is the seller and B is the buyer. Okay, so obviously seller is selling the property to B, of course for any cost, for a cost, and B should pay it. Otherwise obviously A will become an unpaid seller and he can file a case against the buyer that A has not received the money on time or a proper specified money as per contract. So obviously this is obvious as per Indian Contract Act that the party or the seller or the transferor, the party when he is transferring any property or goods to some other party, something in return, and that also must be in value, he should receive. That is consideration explained in section 2D of Indian Contract Act. So basically this is something in return. Always this something in return means a money or a value. It always fixed at the desire of the promissor. Who is a promissor? You can say the person who is giving the property is a promissor. I said the giver we called it promissor and the receiver is called as promisee. So obviously the seller will fix the price now. So obviously consideration must be at the desire of the promissor. So always consideration fixed at the desire of the seller or the giver or the promissor. And consideration, you can say it's a value or money, always move from promisee to promissor, promisee or any other person to the promissor. So promisee means the person who will receive the property or goods, that person is supposed to pay the money. Got it? So I am taking or receiving the goods in exchange of money, so I should pay the money. So always the consideration will move from promisee to promissor or from any other person to the promissor. Continuation is there. Consideration are of three types. Okay, first is executory or future. Next is executed or present, past. So basically I'm telling you, for example, executory or future means you entered into a contract, already A and B entered into a contract, and A said like we already contract executed between A and B, but in the contract it is written like B will pay once the contract got executed or after execution of the contract B will pay. That means the payment will be done in future. Okay, after entering into a contract the B will make the payment. So this type of situation, like where the consideration is moving in future after entering into a contract, that is known as executory or future. So here means promise to be performed in the future. So I promised you, you have transferred a property today. I promised you, like, I will pay you the whole amount by the end of this month. So what happened? Today you transferred the property, we entered into a contract, then I am paying you. So the payment is happening in future. So this type of consideration is known as executory or future. For example, like A makes an engagement with B to marry her in future. So now they enter into they have done the engagement, but actual marriage will be in future. So this is also like executory in future. Next is executed or present, instantly. Today only, now only A is transferring the property to B, and immediately B is transferring the money to A. So on the same date or in same day actually, so the transfer of property and the transfer of money is happening instantly. So for example, you are going to a shop to buy some bread or some eggs or etc., and you ask the shopkeeper, please give me 10 eggs or means bread. Shopkeeper has given in your hand, and you have given the cash in the hand of shopkeeper. Okay, you have given the cash to the shopkeeper. So what happens, this is an instant exchange of things, means you have given the property, means the shopkeeper has given the property to you, and in exchange you have given money for the property to the shopkeeper. So this type of transaction, we called it executed or present. That means at present it's happening. And past means already money transferred, now we are entering into a contract. Okay, so consideration took place before and completes before the promise is made actually. For example, like you have seen, like for houses belongs to father. Now already father bought the house, already father paid the money, all has been done. Now father want to transfer that house to his son. So whenever this transfer is happening, only they will execute the documents, not the money, because already the money transferred. Got it? So consideration moved before, now the party is entering into a contract. So this type of things, when the consideration moved before, we called it, it's a past consideration. So I think it's clear, like consideration are of three types. One is you already entered into a contract, but money will move in future, that is executory or future. Instantly exchange of property as well as exchange of money is happening, that is executed or present. And lastly is already consideration is moved, now we are going to enter into a legal documents, that is we called it past. Whatever money the buyer will give or transfer, it should not be unlawful. What do you mean by unlawful? You can say illegal, void. Okay, that means it should not be the black money, like that. It should be lawful money, means lawful. It must not be opposed to public policy. That means it should not be against public. Not be, it should not be against public. Okay, that means, for example, I can tell you, like you are the uh, for example, A is the caretaker of a complex. A is the caretaker of a complex. Now, A collects the maintenance amount from all the flat members. Got it? Now, all the flat members are giving the maintenance amount to this A, who is the caretaker of this complex or this apartment. Now, A is using the public money, that maintenance amount, for his own purpose. Like A is buying something of his own with that money. Okay, so we can say like the money is the public money, and that is against public policy. You cannot utilize, you cannot use public money for your own purpose. So whatever money you are going to give it for buying the property, it should be your earnings. You should not do the robbery, or you should not take from other. You should not, like this property, you should not use the public's property to buy the property of your own. So this is against public policy. And I said Consideration must be always in something in value. That means you should take the money in return. You should not take something means some other, I'm giving you one flat, in exchange you are giving your property to me. No, it should not be something in return means something in asset is not acceptable. Okay, some money you should give me. It may be less or more, but money you should give to the seller in exchange of that property. So this is all about consideration. Now we are done with, first of all, the offerer made the offer. Now the offer got accepted. Both of them promise to each other that they will transfer the property and money to each other. Once promise is done, they will, both of them, both the party will sit and they will fix the consideration. Okay. Now when all these three is done, they will enter into an agreement. Now agreement is defined under section 2E of Indian Contract Act, which means every promise and every set of promises forming consideration for each other. Now, I can tell you in a very easy way what is agreement. Now, I think everyone have seen the format of agreement. It's the same like my name, okay, daughter or son of my father's name resides at this, entering into an agreement with Mr. B, son of this, okay, or daughter of these resides at here, then terms and condition. There's a fixed format we actually use for agreement, contract and all. Now there is a minor difference between that agreement and contract. What is agreement? Whenever we prepare this format in a paper, loose sheet of paper, okay, that is actually an agreement. That means agreement is something which is not enforceable by law till now. Got it? So every promise, or everyone has promised each other, and all these promises, on the base of these promises, both the party have fixed the consideration. Then only they are eligible to enter into an agreement. So agreement means a loose sheet of paper where they are preparing the format, and in that format they are writing everything and signing and all. Basically, no court stamp or signature is there. Got it? This is agreement. Now what is contract? I can tell you, there is a slide for contract, but still here only I will tell. In a loose sheet of paper, whenever you are preparing the format for your things, terms and conditions and all, we called it agreement. Now whenever you will take these papers to court for stamping purpose or for legal validation purpose, after inspection, when we will stamp it and say it accepted and it's okay, so immediately this agreement will convert into contract. Got it? So the same paper, same thing, only the difference is the court signature, court stamp. So when the loose sheet of paper, we are preparing the format of agreement and we are writing one party name, their particulars, entering into agreement with the other party, their particulars, terms and condition, consideration details, everything we are preparing the agreement. Before entering into the court, that name will be, we call it as an agreement. Whenever you are carrying those papers, we are entering into a court for stamping purpose, immediately that agreement is coming converted to the contract. Agreement is having one formula, that is whenever offer is got accepted means offer plus acceptance equals to agreement. So the person who is offering, and once the other party is accepting, then only the buyer got fixed, and then the seller and buyer will enter into an agreement. So agreement is equal to offer plus acceptance. Next come to reciprocal promises, 2F. Section 2F is defining the term reciprocal promises. Let me read first. Promises which form the consideration or a part of the consideration for each other are called reciprocal promises. In other words, it is a promise in exchange for a promise. In case of a reciprocal promises, each party to contract is a promisor as well as promisee. So in a very easy term, I am telling you, what do you mean reciprocal promises? Here, both the party is promising something. Got it? That means, for example, you take A said to B that A wants to sell his property to B, and B promised to A that he is having one plot of same value. In exchange, he will give that plot to A. That means both the party will give some property to each other. Okay, here in return, value is not coming. Got it? Reciprocal promises means one party is promising that he will give some property to other. In exchange, the other party is also promising that he is also wants to transfer the property of same value to me. So in that cases, A is also offering to sell this property, B is also offering to sell this property. So in that cases, both are promisor and promisee. In reciprocal promises, both are, we can say, they are promisor and promisee. Got it? So reciprocal promise means reciprocal. That means I am promising that I will give a property to you. You are also promising that you are also wants to give some property to me of same value. Okay, so I want to give this pen to you. Instead of giving me the money, you will also give your pen of same value to me. So this type of promise we called it reciprocal promises. 2G of Indian Contract Act explained void agreement. Now we will read two types, that is two terms, that is void and voidable. But agreement may be of only void. Okay, first let me tell you what do you mean by void. Illegal agreement. Void means it is wrong from everyone's side. Okay, that means it is wrong from every corner. You cannot make it valid or you cannot make it right. That is known as void. And void agreement are of only one type, that is void agreement. Okay, which means an agreement not enforceable by law is said to be a void agreement. That means already I said na, in a loose sheet of paper, whenever we are preparing that format, writing the particulars about two party, so obviously this is agreement where court stamp is not there or signature is not there. Whenever you will take this paper in the court, after inspection, if court reject these papers and court says like we can't stamp, there is some dispute, we can say like this agreement is not enforceable by law, rejected by the court. In such cases, this agreement will become void. That means you cannot make this agreement valid. So agreement can be of void only because whenever there may be some dispute relating to the consideration, property papers, everything. Okay, something. So in case the court after inspection reject your papers, okay, then we can say like this agreement is a void. You have to make it freshly or you have to change as per the instruction given by the court. Now come to the main thing, that is contract. Finally, contract is defined under section 2(8) of Indian Contract Act. So already I said once, still I'm telling you, an agreement. Okay, an agreement means the format whatever we have written in a loose sheet of paper, only the difference is court stamping is not there. Whenever you are taking this paper to the court for stamping purpose, when they will enforce these papers, enforceable by law, we can say, okay, when the court will accept these papers after inspection and will give a stamp, okay, we can say like this agreement became contract. That means if this agreement converted to a contract. Got it? Contract are of two types. One is void and other one is voidable. In next slide, I will explain void and voidable contract. But Here only I want to tell you the difference. The term void, wherever you will see this term void, you can see, like, you can write this means illegal, completely wrong. You cannot make it right in any way. It is wrong from every corner. That is void. Okay, marriage with a minor, for example, minor marriage. Okay, it's a void. You cannot do it. It's an illegal thing. You cannot make it valid also in any way. So anything which you cannot make it valid in any way or which is illegal in nature, that is, we called it void. Then what do you mean by voidable? What do you mean by voidable? Voidable means it's not completely illegal. Okay. That means for the time being, it's not valid. For the time being, it's not valid. But yes, it can be rectifiable. That means voidable contract means the contract currently it is not valid, but it's in your hand. You can rectify it and can make it valid. I can give you one example. If you all know, like our Hindu Marriage Act, there is Mohammedan Act also. Okay, Mohammedan law. In Mohammedan law, it says, like, when a Muslim guy wants to marry a Indian lady or Indian girl, or I can say Hindu girl, if a Muslim boy wants to marry a Hindu girl, as per this Mohammedan law, it is says, like, first Hindu girl needs to convert into Islam, then she can marry the Muslim boy. If not, if the Hindu lady or Hindu girl don't convert herself to Islam, then the marriage will become voidable. Why voidable? That means it's a one rectification needed to make it valid. So when the Muslim boy wants to marry a Hindu girl, first the Hindu girl needs to convert into Islam. It is written in the Mohammedan Act. So what happened? Until and unless the Hindu girl converting herself into Islam, the contract is voidable in nature. That means once she convert to Islam, the contract from voidable, it will become valid. Got it? So difference between void and voidable is void means completely wrong, illegal, and voidable means for the time being it's not valid or wrong, but it can be rectifiable in future. You can rectify that thing to make it valid. That is voidable. Okay. I of Indian Contract Act explain voidable contract. What is voidable contract? Voidable contract is a contract which ceases to be enforceable by law at the option of the parties but not at the option of others. That means here only the parties can rectify the fact. Voidable means for the time being it's not valid, but you can rectify. Now this means to make it valid only the parties can do so. Third party cannot interfere into the matter. Third party cannot make it valid. Got it? So whatever mistakes has been done, it's only by the parties. Now for such mistakes, we can say this is voidable. Now to make this voidable to valid, only this is there at the option of parties. That means parties only can make, so means can rectify this mistake and make this convert from voidable to valid. Here in this case, in voidable contract, third party cannot interfere. Third party means you can say any broker, lawyer or other party. Here only at the option of it, it can be enforceable by law only at the option of parties but not at the option of other or others. That is voidable contract. And next is 2J, define the term void contract, because contract are of two types, void and voidable. Voidable means for the time being it's not valid, but it's in the hand of parties to make it valid or rectifiable in future, only at the option of parties. Third party cannot do so. Okay, but 2J is a void contract, which means uh, it cannot be enforceable by law. That means whenever this contract, whenever you are taking the agreement to the court after inspection, court is simply rejecting your contract due to some disputes. Got it? So when your contract is ceases to be enforceable by law, cease means restricted. So court is restricting your papers to be enforceable by law. Legally, it is not enforceable. That means legally you are not getting the green signal from the court. In such cases, that contract is void, invalid, or illegal. So in that cases, you don't have any option to make it valid or rectify it. You have to make a fresh contract, or you have to first, you need to know why your contract is void. For example, I can give you some example of void contract. Void means illegal. For example, like illegal consideration is involved in that contract. Got it? We can say your contract is totally void because illegal consideration. That means illegal money. Maybe you are using black money for buying one property. Void contract. Next is your object is void. Object means the asset or property whatever you want to sell. Maybe you are selling the smuggling products, or you are selling the cocaine which is a banned product, drugs. So these are all banned, okay, restricted by law. So if you want to do the transaction with this type of goods, immediately your contract will become void. You cannot make it valid, illegal. Okay, so thank you. These are the important definitions coming under the Indian Contract Act. Hope it is clear. If you are still having any query or confusion, you can write in my comment section. I will write. Uh, I will solve your query, and wait for the second video. Soon I will come with the second video. Next topic, that is essentials of Contract Act under the Indian Contract Act. Okay, so hope you like it. Don't forget to hit the like button, also the subscribe button, and share with your friends. Okay, bye.